Good morning, sir.
Good morning. So just prior to cross-examination, there was just a minor issue that I wanted to address on the record, and my friends have graciously permitted me to come up and deal with it now. And it's just a minor point regarding during Dr. Von Gernet's examination in chief last Tuesday. He was asked a question that came from the court, and it was about whether the Pick and Long Lake bands were signatories to the RST.
Yes.
And the witness responded that, well, they didn't have representatives there. It was done through proxy. And just for the record, that was the transcript at page 123 to 124. And this is, in fact, a central matter of dispute in the Machano litigation. And due to the terms of the Group of Seven's intervention in this case, this is, of course, not an issue in this case, nor does any party have the intention to put this matter into dispute in this trial. So I've discussed the matter with my friends, and I can represent on the record that no party will be relying upon the statement of Dr. Von Gernet regarding the representation of the Pick or Long Lake bands, and that no party will be asking this court to make any factual findings with respect to that issue.
All right. And what have you thought? What is the best? If I don't remember in what context I asked the question, but is there some better statement that I can make about the status of, who was it, the Pick and Long Lake bands? Is it just that they're one of the Group of Seven and their status is currently the subject of litigation? Is that the best way to put it?
I think that's fair, and I would also rely on the terms of both the intervention order and the statements of claim by the various members of the Group of Seven in this matter, which is simply that our participation in this trial is on the basis of our contingent interest under the Robinson Superior Treaty.
Thank you. Can you give me a bit of the context in which I asked the question? Is that?
I believe the question arose in the context of distributions of the annuities following the Treaty Council in 1850, and distributions being made to the Pick and Long Lake bands. And I believe it was in that context you raised the question about whether they were represented at the Treaty Council in 1850.
Okay, thank you.
Okay. Thank you very much.
And you have said on the record where on the transcript it was, so I can go back to it. Page
Yeah, so it would be day
124.
25, page 123 to 124 of the draft transcript.
Right. Thank you very much.
Good morning. Dr. Von Gernet, I believe you know I'm Glynis Evans, Counsel for Canada, and I'm going to ask you some questions before my friends from the plaintiffs do. I'm going to be using your slide deck and referring to specific slides and asking for some clarification or follow-up on some of those points.
Sure.
I've got your slide deck with you. So the first one, not the perspectives report, but the
Exhibit 52.
their just demand report. That's right, Exhibit 52. Thank you. And I'm going to start with slide 55. I'll wait for everyone to get there, but my colleague has it on the screen.
Let me triple check. This is Exhibit P turned into Exhibit 52.
That's right.
Can I just ask a question? Was the slide deck from the second report made an exhibit?
Yes,
Got it. Thank you very much.
So 55, we want to start with slide 55. In your first bullet point, you say there that at the time of Confederation in 1867, the annuities payable under the Robson Treaties, which was $4,400,
Yes,
continued to be drawn from a CRF now controlled by Canada. And by Canada, you mean by the Dominion. Is that right?
Yes,
So throughout this cross-examination, Dr. McGurnett, I'm going to try and refer to Canada as the Dominion to keep it separate from the province of Canada.
understood.
So you told us that the Dominion auditor, Langton, determined that a capitalized amount of $88,000 would be needed, it would need to be set aside to generate $4,400 in annual payments. And this would cover the fixed annuities of $2,400 for the RHT and $2,000 for the RST.
Yes,
Right? So this isn't really rocket science. The $88,000 is not controversial. That's simply what's needed if you're assuming an interest rate of 5% in order to generate $4,400 every year in perpetuity. Is that right?
that's correct.
So then you say that at the last bullet point, the auditor proposed that this amount, $88,000, along with the capitalization of the other annuities, being those not relating to the Robinson Treaties, be charged against the old province of Canada, since succeeded by Ontario and Quebec, as part of its pre-Confederation debt. So you say the auditor proposed that it be charged against the old province of Canada, and in fact, it was charged against the old province of Canada. Is that right?
Well, the proposal is on the next slide,
So my question.
which is in the future, and then
My question isn't about the proposal, it's about what was actually done. And I'm saying what was proposed was in fact actually done. This $88,000 was charged against the province of Canada.
Yes.
Is that correct?
yes,
And so that means that it became a debt of Ontario and Quebec conjointly, right?
yes,
of the provinces, Ontario and Quebec jointly.
That's correct. Because it was a debt of the province of Canada, it then became a debt of Ontario and Quebec conjointly. Is that right?
yes.
Thank you. So if we turn to slide 57. The fourth bullet point, you say, as in every year since 1851, the funds needed to pay the annuities did not come from proceeds from the lands north of Lake Superior and Huron. Canada paid for the capitalization from the CRF. Here we're obviously talking about post-Confederation. The Dominion is now in existence and the Dominion is paying the capitalization from the CRF. Is that right?
That's correct.
But in fact, although Canada paid out the annuities, those annuities were charged as a debt of the province of Canada and ultimately became the responsibility of Ontario and Quebec conjointly, right?
Well, the intention to have Ontario and Canada, sorry, Ontario and Quebec pay that ran into the jurisdictional complications, and that's where the disputes arose.
And we'll get to that. So you say it was, in the last bullet point, it was Canada's intention to have the capitalized amount added to the debt of the late province of Canada. And in fact, that is what happened. You told us just earlier that in fact, that is what happened. It was charged to the province of Canada as a pre-Confederation debt. And it was then became a debt of the provinces of Ontario and Quebec conjointly. You told us that actually did happen, right?
Yes, I don't pretend to know what, how that accounting actually worked. And all I know is that that was the intention, and that was it was disputed ultimately by the provinces of Ontario and Quebec.
But it ultimately was approved by the arbitrators, and that's what actually happened.
Yes,
Right?
at the end of the day, that's what happened.
Sure. So here I think it might be helpful to look at the Constitution Act. And are you familiar with these provisions of the Constitution Act? I'm looking at, we brought up on the screen, the Constitution Act 1867, otherwise known as the British North America Act.
I ditto that.
I'm sorry?
I ditto that.
Okay. I thought we're also used to the Constitution now. All right, so we're looking at the Constitution Act. I want to take a look at it. And my colleague has brought up on the screen a reproduction of certain sections of the Constitution Act 1867. It's otherwise known as the BNA Act 1867. Are you familiar with these provisions? And in particular, I want to look at section 111 and section 112. Are you familiar with these provisions of the Constitution Act, Dr. Von Gernet?
Well, I'm not a constitutional scholar, but to the extent that I quoted from those or referenced them in my report, I read them as an ethno-historian, not as a constitutional scholar. So what happened was I looked at the reasons for the dispute, and they kept alluding to these various provisions of the BNA Act. So I took the time to read those provisions, and I simply reiterated them in my report.
So you're not an expert in constitutional history then?
No, I don't pretend to have studied the Constitution.
And obviously you don't have legal training as well, is that correct?
That's correct.
But you do agree that section 111 states that Canada shall be liable for the debts and liabilities of each province, including the province of Canada, existing at the Union.
Yes, that's what it says.
And then section 112 provides that Ontario and Quebec conjointly shall be liable to Canada for the amount, if any, by which the debt of the province of Canada exceeds $62 million, was said at the time. Right?
Yes, it's my understanding that that was increased later on, but at the time of the Constitution, that was the estimate.
And is it your understanding that these Robinson annuities were part of the excess debt of the province of Canada?
That's a legal question.
Well, unless you have had an understanding and or that you put your understanding in this report.
No, the only thing I put in my report relates to the understanding of the parties in dispute. I have no separate understanding of whether it's, one party was correct as opposed to the other.
Okay, I'm happy to move on. All right, but you did tell us, I'd like to move now to slide 60. You did tell us that you're not a constitutional historian, and you weren't actually retained to look into the arbitrations between Ontario, Quebec, and Canada, but you took a look at them generally. Is that right?
Yes, I was. Well, first of all, I was excuse me, I was mandated to look into the actions of the Crown in respect to the Robinson treaties. And in the course of doing that, there were a number of different events that transpired, including the arbitration proceedings, which I thought were germane to my mandate. I also understood that the arbitration and other judicial decisions that were made later in the century would also be covered by other experts. So the extent of my inquiries for my mandate was just solely to memorialize my understanding of the correspondence and events that took place in respect to those arbitrations and other judicial proceedings.
Thank you. So is it fair to say then, you really aren't an expert on how sections 111 and 112 of the Constitution Act 1867 actually operate? Is that fair to say?
Yeah, I think that would be fair to say. As I said, I'm not an expert in constitutional law or in the Constitution itself. But I necessarily have to refer to it because it would not make any sense either to me or to anyone reading my report if I didn't refer back to the constitutional provisions that all these Crown actors were referring to.
So here on slide 60 of your exhibit 52, you reproduce a part of the award of arbitrators of September 3rd, 1870. And these were the arbitrators that were appointed under section 142 of the Constitution Act. Is that your understanding?
Yes,
And these arbitrators were entrusted by virtue of section 142 of the Constitution. They were entrusted with determining the debt, the excess debt between Ontario and Quebec and how it should be shared conjointly between them. Is that right?
that is certainly one of their tasks. I don't know if it's the only one that they assumed, but it's certainly the one they derived directly from section 142.
And the passage you've quoted from their September 3rd, 1870 decision says, the arbitrators held that all the lands in either of the said provinces of Ontario and Quebec respectively, surrendered by the Indians in consideration of annuities to them granted, and here's the relevant part, which said annuities are included in the debt of the late province of Canada, shall be the absolute property of the province in which the said lands are situate, etc. So the point here is this not a finding by the arbitrators that Your
Are
Honor,
you?
I would say I'm not asking for a legal opinion. This witness has, even though this witness has told us that he's not a lawyer or a constitutional historian, much of his report deals or purports to deal with constitutional history and the significance of these passages from the arbitration. And what I intend to ask the witness is to confirm that the arbitrators in fact held that the annuities were to be included in the debt of the late province of Canada.
Well, let's just say you established, and I don't think that the witness resists this characterization at all, that he is not a constitutional scholar or here as an expert on what the arbitration findings were. And it seems to me you will do a better job arguing what they mean than having this witness take a stab at them.
Thank you. I'll move on then to a question about the last bullet point. When you say in 1895, this decision was revisited in the Supreme Court of Canada, what do you mean by revisited?
Well, I think I testified last week that the Supreme Court of Canada, or at least the Chief Justice Strong, referred to this 1870 decision and said that something in that decision had been decided already as a matter of law.
So how does that make the decision revisited if it was just mentioned by Chief Justice Strong to say that it had been made, the decision had been made? Is that what you mean by revisited?
Well, I'm using the term revisited loosely, not in a legal sense. It's not a legal term.
So you
It's
don't
just-
mean that it was appealed, for example?
No, not at all.
Or
No,
challenged?
No, I'm just saying that, as I said last week, and as I said in my report, the Supreme Court returned to this, is perhaps a better word,
Well-
and,
I think we'll leave it to the judge to determine. These are legal decisions that
yes,
the judge will be better placed to read and interpret than you are.
absolutely.
All right, then I'd like to turn to slide 96. So here we're talking about, or you're talking about, you can see from the heading of that slide 96 of your exhibit 52, the 1875 annuity augmentation. And you told us that Canada, the Dominion, had begun paying augmented annuities up to $4 per person as of 1875. Is that right?
Yes,
And the idea had been that Canada would pay this $4 annuity and worry later about who was actually responsible for it, as between the Dominion, Ontario, and Quebec. Is that right?
yes,
And is that why in your first bullet point, you say what had originally been contemplated as an interim measure awaiting judicial review respecting which crown was responsible for funding the annuities? This is what you mean by the fact there was to be a decision made later among the parties as to who would ultimately be responsible for that increase up to $4 per person. Is that right?
yes. At the time that Blake and Mowat had agreed that Canada should pay the difference between the pre-augmented and augmented annuities, it was also understood by both that this would, the matter of who would actually be ultimately responsible would be adjudicated by the courts.
So when you say in that bullet point that it turned into a permanent annual charge against the Canadian or Dominion budget, how do you reconcile that with the idea that this really was an interim measure yet to be determined as to who should be permanently responsible?
Well, the two are not mutually exclusive because they were awaiting a judicial review that did in fact take decades. And so perhaps permanent is not a good word. It's temporarily permanent in the sense that instead of it being just for the year 1875 or 1876, it ends up being for the rest of the century.
So it was an interim measure because ultimately the Dominion, Ontario, and Quebec entered into a new set of arbitrations with entirely new arbitrators in 1892,
Yes,
partially for the purpose of determining who should be responsible for the augmented annuities. Is that right?
yes.
So on that slide 96, in the last bullet point, you say, since the condition in the Robinson Treaty augmentation clauses, by which the then understood maximum annuity of $4 per capita became payable, was thought to have been met, there was no need to keep track of future proceeds from the lands. But in fact, there was a need to keep track of future proceeds because the issue of which government was ultimately responsible had not yet been determined. Isn't that right?
Well, no. As I said, and repeatedly throughout my report, once you reached what was understood to be the $4 maximum, or the maximum under the treaty, which was $4 per capita, there was no need to keep track of the proceeds because they're already being paid the top, what was understood to be the top of the maximum annuity. And the only reason for the proceeds now to be relevant was because of the arrears issue. They didn't know at what point prior to 1875 they could have been payable. And that was basically sort of the reasoning behind the Crown actors during this period. They weren't looking for, I mean, you know, let's say for the sake of argument that let's say they went back into the proceeds and found out that in fact, the Anishinaabe were not entitled in 1876 to an annuity increase, which was in fact the case if you went year by year, then they're not about to revoke the difference. I mean, once you promise the Anishinaabe $4 every year, the Anishinaabe now expect the $4 every year. So year after year after year for decades, they're getting the $4. So there's no need to think of the proceeds from the lands until you reach the point in that arbitration process where the parties finally said, you know what, let's just settle this and let's just look back and reconstruct what happened and come to an agreement as to which years in which years the annuities were payable. And then we'll come up with a figure that can be capitalized and that can be then added to the, you know, to the debt of the
And when that,
provinces.
and when that happened, Ontario didn't just look up to 1875. When the annuity was augmented to $4, they went and looked at proceeds beyond 1875, didn't they?
Yes, they went to 1892.
And why did they go to 1892?
Well, it's a good question because it's not as if, you know, the parties are going to suddenly say, oh, well, during these years, we should go back to the Anishinaabe and get our money back because during these years, you know, they weren't eligible to get $4. They're not going to do that, right?
Dr. Von Gernet, you say it's a good question, why Ontario eventually went through its records to determine what the proceeds of the lands were. You say in your report up to 1892. In fact, we've heard in other testimony that they did that up to 1897. And you say it's a good question as to why they did that. Do you not know why they did that?
Well, ultimately, they had, you know, this was in the midst of the parties trying to settle an amount. And the best way to do that is to find a capitalized amount. And the only way you're going to reach a capitalized amount is if you have the data to know how much you were liable for to create the interest from that capitalized.
When
amount.
you were liable for, who are you referring to? Whose liability are we
Well,
talking about here? Is it not Ontario's?
Well, I mean,
Was Ontario not concerned about its own liability?
The reporter was first off there asking for a slowdown, so we'll go with that.
Was it not Ontario who was concerned about its own liability? And that's why it did the research to determine what the proceeds were going well beyond 1875.
And by that time, there had been an arbitration award. And the parties,
Which arbitration award are you referring to?
I don't remember the numbers. They're sometimes referred to by numbers, but in the original primary sources, they're not numbered.
Well, maybe you can help us with this. Which arbitrators
This is the second set of the new arbitrators.
that started their process in 1892?
Yes.
So going back to that arbitration in 1892, that was not an arbitration under section 142 of the Constitution Act, was it?
Well, there's a series of arbitration awards. So I'm not sure which one you're referring to. We'd have to read the,
I'm not talking about the award, I'm talking about the arbitration process.
yes.
There was an arbitration process in 1870 pursuant to section 142 of the Constitution Act,
That's correct.
1867, to determine how to split the excess debt between Ontario and Quebec,
Yes,
correct? 25 years later, there was an entirely separate arbitration that happened by virtue of the agreement of the parties, Ontario, Quebec, and Canada, each passing parallel legislation for a
yes,
new set of arbitrators to deal with a number of financial issues between the Dominion, Ontario, and Quebec. Is that correct?
yes. I actually explained the context of that in my report. You could just find the section.
If you've agreed with my summary of what I believe was your evidence about this, I don't think it's necessary for you to turn it up. Really,
Well-
where,
He thinks it is necessary, Your Honor. You let him. That's his plan.
Well, let's see the flow. Sometimes I have found Dr. Von Gernet goes way beyond the question. So I'm okay for this prompt. We don't need to, if we don't need to put it up, we don't need to put it.
excuse me, while I check my notes. I've forgotten my original question. And I don't really think that, but I'll let you respond as you wish, Dr. Von Gernet, and then we'll get back to, I think, the point we were talking about, Ontario's need to keep track of future proceeds. rather
Yeah,
than-
so your question had related to, what the difference between the 1870 arbitration and what was being arbitrated in 1892 and thereafter, right? And I deal with that on page 372 of my report.
Is there, I'm fine with that. Is there anything else you wanted to say about it?
Well,
before we move on?
I just wanted to say that in 1891, what the parties agreed to for arbitration was whether and when the first annuity augmentation had become due and payable, and assuming it had become payable, which government was responsible for payment. And so they decided to deal with the second question first. And then that's where the 1895 award comes from, which then went to the Supreme Court of Canada. So that's the chronology.
All right, and we'll get there. So right now, I'm back to the original question I asked, which is, we saw that Ontario, in fact, did do calculations up to at least 1892. That's what you said in your slide deck. So if the proceeds of the land didn't matter after 1875, in your opinion, why then did Ontario go to the trouble of figuring out these proceeds up to at least 1892? And you said to me, that's a good, I think that's when you said, that's a good question. Do you know why they did?
Yeah, from a point of view of the Anishinaabe, it didn't matter because they were getting their $4 that they had asked for. And, according to Blake, their just demand had been met. And from Ontario's perspective, Canada was paying this amount all along. Obviously, Ontario, irrespective of how much Canada was paying, still had to come to terms with Canada and Quebec on this issue of their liability. And so Emilius Irving, who was counsel for Ontario, requested that all of the proceeds that were ever collected and all the expenditures ever made from the two periods, that is from 1851 to 1867 and from 1867 to 1892 would be assembled. And then that would be presented to the three parties and they would come to a settlement as to how much of this would be capitalized. And that figure would then be the agreed upon figure that was owing by Ontario.
Was owing by Ontario.
Well, it was owing by the provinces as opposed to Canada.
All right,
And,
so
every time I hear you now say Canada, you're
This
speaking of the
Dominion.
Dominion, and that would be helpful. Thank you.
Yes.
so you said Ontario still had to come to terms with their own liability. And does that provide a reason why Ontario was still looking at the proceeds from the land? Because they still needed to come to terms with their own liability?
Well, this now is the consequence of another award, right? This is not. I mean, Ontario understands that it has these potential liabilities, and so, but because the matter is so complex, they think there's some correspondence between Ontario and Quebec and the Dominion, suggesting that why don't we just settle this once and for all, and so that the liabilities, if any, are articulated. They did so, they went through orders in council, they presented to the arbitrators accepted it, and that was the end of it.
Okay, we'll come back to that as we go through your slides. So I'd like to turn to slide 97. Again, you reiterate that there was no need to keep track of future proceeds from the lands for treaty purposes, something that we just discussed, and we will get back to. You also told the court in your testimony that the unfinished business that you're referring to in the title here was whether the augmentation should have happened before 1875. Is that right?
Yes,
But another piece of unfinished business was who was going to be ultimately responsible to pay the annuity increases, both before and after 1875. Was that not still unfinished business as well?
yes, and I take pains to go through that to the rest of that chapter.
All right, let's turn to the next slide then, slide 98. In the second bullet point, second sentence, you say, in 1875, Crown actors believed that that condition had by now been fully realized. And the condition being talked about here is the lands now producing sufficient proceeds to trigger the augmentation. Is that right?
Yes,
So when you say Crown actors believed that that condition had been met, which Crown actors? Did this include Ontario? Did Ontario believe that the
Yes.
condition had been fully met?
yes, I mean, Mohawk was on record for saying, I asked party and party said, this is the amount. And that's enough to provide the funds necessary to augment these annuities. And Blake, of course, was also of the same view. So there you've got the Attorney General of Ontario and Premier of the province, as well as the Minister of Justice for Canada, agreeing that it was time to augment these annuities.
And isn't it the case that Ontario later determined that they were mistaken? They later produced figures to show that in fact there were not sufficient proceeds from the lands in order to augment the annuities because the lands had actually suffered losses in many years before 1874.
That's correct.
So Ontario essentially changed its mind on this.
No, I don't think it. Well, I don't know which actor you're talking about. Nobody changed their minds. What happened was, Mowat and Blake both came to this understanding. Mind you, for the RHT, it was a sheer guess.
We'll just keep it to the RST.
So in the case of the RST, it was understood that there were sufficient monies there, even though they didn't know the net amount, that, they thought it was enough. But when Johnson's figures were produced, which keep in mind, were produced for the sole purpose of the arrears question, his more fine-grained analysis showed clearly that there were periods where there were losses, and in fact, if you put the two treaties together, there was a net loss. So it's not a matter of anyone changing their minds. It's a matter of Johnson, for the first time, producing the kind of fine-grained analysis that allowed a better picture of exactly what the gains and losses were from year to year during the period up to 1877.
All right, so
Could
maybe,
I jump in there? Your question was, so they changed their minds? And your answer was no, they got some new numbers. So can I ask, so they changed their position?
There was no position, as far as I know, there was no position taken as a consequence of the Johnson figures. I never found any expression of a position taken. This is simply Ontario providing Canada with what Canada had requested. Canada requested precisely this amount. Remember, it was Meredith who wrote that rather strange.
I just said, you answer the question.
Yes.
Say no.
all right, we'll get into more of that as we get further through your slides, once we get into that Dominion provincial arbitration starting in 1892. But let's just stick to where we are in the slide deck and move to the next slide, slide 99. Here you are still addressing the issue of arrears, so amounts due between 1850 and 1875. And you say for several years, the only action taken was Canada's repeated request that Ontario furnish particulars on proceeds, and Ontario's repeated request that Canada provide a definition of the RHT boundary so it could fulfill the request. Why was it believed that the Dominion would have better knowledge of the boundary of the treaty than Ontario would, Dr. von Gernet?
The treaty was signed between Indigenous peoples and the Crown. Canada, by this time, was understood by Ontario to be solely responsible for any matters relating to Indians under Section 9124 of the Constitution, or of the BNA Act. So the matter of treaties and their interpretation was something that Ontario logically felt was a matter for the Crown. This was an Indian matter. This was not a lands matter.
Can I just stop you there and say, does the Constitution not refer to Indians and lands reserved for Indians? Should we pull that up, or would you agree with me?
Yes, that's what
And lands reserved for Indians. But when we're talking about the boundary of, in this case, the Robinson Huron territory, we're not talking about lands reserved for Indians. We're just talking about the parameters of the lands that then became part of the province of Ontario, right?
Yes, but Ontario was not involved in signing this treaty. I
Was
mean,
the Dominion involved in signing the treaty?
that's true. There was no Dominion at the time. However, as I said, anything dealing with treaties and Indians was understood to be under the Dominion's jurisdiction. Ontario, I mean, I suppose if you think about it, I mean, anyone can read the Robinson, the RHT, the Robinson Huron Treaty text for themselves. You know, it's not something that only Canada can do. So Ontario could easily read the same text, but the problem is this, is, you know, if Ontario interprets it one way, you know, and finds that, you know, Canada doesn't agree with it, they're still going to need an opinion from Canada anyway, right?
Or why could Ontario not ask the Anishinaabe who are living in Ontario? We're talking about lands in Ontario. Why couldn't Ontario ask the Anishinaabe, help us determine what are the parameters of the boundary?
Well, because the Anishinaabe themselves didn't know the boundary either.
So
Nobody knew the boundary.
why was it assumed then that the Dominion would know?
Well, I mean, the Dominion might be better positioned to know what the intent had been in 1850 when Robinson gave the, you know, I mean, as I said, the whole business of Indians and Indian affairs was considered by Ontario always to be under the Dominion's jurisdiction. And this was an issue of treaty interpretation. This was not an issue of you know, lands. I mean, obviously Ontario had surveyed the lands, or was in the process of surveying lands, but the ambiguities of the RHT eastern boundary are intractable even to this day. And you know, it's not surprising that Ontario sought Canada's definition.
So you had said in your answer there that the Dominion would be better positioned to know what was intended in 1850 than Ontario would be. What leads you to that conclusion that the Dominion would be better positioned than Ontario?
Because the entire treaties, this is true of all the treaties, not just the Robinson treaties, were administered through the Dominion, through the Department of Indian Affairs. And the Crown Lands Department simply dealt with lands and proceeds from lands. It
The
didn't.
Crown Lands Department of Ontario, you're speaking about.
Yes. The Crown Lands Department of Ontario. So the matters of treaty interpretation, you know, were ones that,
Ontario didn't feel it had
yeah,
enough
obviously,
experience to know.
Ontario obviously knew this, the treaty text itself. I mean, it had been, you know, widely circulated. Everybody knew what the treaty said, but nobody knew where the boundary was. And if Ontario doesn't know where the boundary is, I don't see why it should not ask Canada. And of course, within a day, Canada came up with a boundary. Once Meredith knew that, you know, this was the issue, Meredith came up with an approximate boundary.
Can I ask you a question then there?
Sorry, just let each other finish. Sorry, Paul. Go ahead. Once Meredith knew that this is the issue.
Once Meredith knew that this was the issue, Canada produced an approximate boundary, which was straight line from the eastern end of Lake Nipissing south to a point where it intersects a line meeting Moose Deer Point on the Georgian Bay. And then once Ontario had that, it at least had a means to narrow down proceeds. But this is an issue that's still problematic today. So I don't see any, to me, it's not totally unsurprising that Ontario sought this information from Canada. If Ontario doesn't know,
I'm just
perhaps-
going to ask you, sir, to confine your answer to the exact question. Okay,
Understood.
thank you.
So did the Dominion have at its disposal more and better information than Ontario did when it read the treaty?
Yes,
What was that more and better information?
the Dominion had in its possession, and I dealt with this in my report. And I suggest that we turn to those pages because that's where my answer is. Okay, so starting at page 312. So that's where I talk at great length of how Meredith came up with this eastern boundary. And there's a map on page 315, which actually outlines his boundary. And then I have a map showing where he may have approximated it along the Bob-Cajun line. And on page 317, right to 319, and particularly page 320, you see that these landmarks, such as Moose Deer Point, they come from correspondence that only the Dominion of Canada had. And this was where the Anishinaabe, who were to the south of Moose Deer Point, had stated that their boundary with the RHT Anishinaabe was at Moose Deer Point. And so you got a straight line across, according to Meredith. Ontario didn't have any of this. This was information that only the Dominion had, because they had the correspondence between the local Indian agent, in this case. It was William Plummer, who was a superintendent in the Indian office in Toronto. And I go on to page 321. So this is the kind of information that the Dominion had, which is the extrinsic evidence that is required to illuminate the RHT boundary, because the fact of the matter is that you cannot, even today, determine what that boundary is unless you have extrinsic evidence. And Sure, Ontario could have come up with their own boundary just based on reading it, but it would have been just as arbitrary. At least here, after they received the Dominion's identification of the boundary, it was based on correspondence and additional extrinsic information that only the Dominion had.
Okay, I'd like to move on to slide 124. Actually, I think we'll go to 125. So here, I think we're now into the time period at about 1895, when an entirely new set of arbitrators has been appointed pursuant to parallel legislation passed by the three different governments in order to determine outstanding financial matters between the Dominion, Ontario, and Quebec. Is that right?
Yes,
And here now we're looking at award number 3 of those arbitrators, the 1892 arbitrators, I'll call them. And that award number 3 is dated February 13, 1895. Is that correct?
yes,
All right. So in point 2, you say the arbitrators confirmed that the responsibility to pay increased annuities for any years prior to Confederation was a debt or liability which devolved upon Canada under section 111 of the BNA Act. Canada, the Dominion. Is that right?
you're referring to,
Your second bullet point on page 125, slide 125 of exhibit 52.
yes, so the full paragraph is on page 373 of my report.
Yeah, we'll take a look at that then. I'll have my colleague put that on the screen, page 373 of your report. Because in your slide deck, you say the arbitrators confirmed that the responsibility to pay increased annuities for any years prior to Confederation was a debt or liability which devolved upon Canada. But if we take a look at the actual award at page, reproduced at page 373 of your report, we're looking at paragraph 4 of the award.
Yes,
And it goes on after saying that it's a liability which devolved upon Canada. And what does it go on to say then? It says, why don't I read out that paragraph 4? This is the finding of the arbitrators in their third award dated February 13, 1895.
yes,
That any liability to pay the increased annuity in any year before the Union was a debt or liability which devolved upon Canada, Dominion, under the 111th section of the British North America Act, 1867, and that this is one of the matters to be taken into account in ascertaining the excess debt for which Ontario and Quebec are conjointly liable to Canada under the 112th section of the Act.
yes,
We'll stop there. So this then means it's Canada is first assumes liability under section 111, but then collects from Ontario and Quebec conjointly. Is that not correct?
Now that's, Your Honor, that is a little question.
Well, my concern,
It says what it says. Fine
All right.
with that.
I think where council is going is whether the slide deck has fully repeated what this section says, and that's not a legal question.
That's right. I mean, I agree. I have no issue.
Okay. So go ahead.
But surely if Dr. Von Gernet is able to opine that. Well, I think I've already got my answer, actually. Dr. Von Gernet, let's go to your third bullet point. It says, of disappointment to the provinces, here you mean Ontario and Quebec, would have been that the earlier capitalization of the annuities did not absolve them of responsibility for pre-Confederation increased annuities that formed excess debt under section 112.
Yes,
And that's where, if we go back to page 373 of your report and look at the actual award, that's that last part of paragraph 4,
yes,
where it says, the arbitrators find that Ontario and Quebec have not, in respect of any such liability, been discharged by reason of the capitalization of the fixed annuities.
yes.
So here we're talking about by reason of the capitalization of the fixed annuities. Here we're talking about by reason of the fact that Ontario and Quebec have already assumed liability for the $88,000 capitalization. Is that right? Is that what's being referred to here? Or do you know?
No, I'm not sure exactly what that means. I wrote or copied out the entirety of the award on page 373 of my report. And I did summarize what my understanding was and how these Crown actors responded. But beyond that, I have little further to say.
All right, so you don't actually know what's being referred to here in this arbitration award, is that right?
Number 4,
That's correct.
well, beyond what's self-evident, I mean, the sections of the act we've already looked at, section 112 and section 111, and I referred to those earlier. I mean, the province of Ontario and Quebec have, according to these arbitrators, not been discharged by the reason of the capitalization of the fixed annuities. So in other words, this is, I'm assuming, reference to what had happened in 1869, 2 years after Confederation, when the annuities were capitalized.
And they became debts of Ontario and Quebec conjointly, is that right?
Well,
Or you don't know?
according to this, they have not been discharged. Just because they were capitalized, Ontario and Quebec were, according to this arbitration award, were not discharged of that liability.
And this was a liability we looked at earlier today that was found by the arbitrators in 1870, is that right?
Yeah, I don't have anything further to say on the 1870 one either.
So when you say in bullet point 3 on your slide, page 125, of disappointment to the provinces would have been that the earlier capitalization did not absolve them of responsibility. Why do you say this would have been a disappointment to the provinces?
Well, because I can't say so much for Quebec, but certainly for the province of Ontario, it had always been of the opinion ever since Mohat had given his legal opinion that Ontario had no responsibility under the BNA Act of paying for any annuities under treaties signed prior to Confederation.
Except we already know Ontario was liable for its share of that $88,000 capitalization. And Moat knew that.
Well, no, Moat didn't know that at all.
Well, that's exactly, what then is being referred to in paragraph 4 when it says Ontario and Quebec have not, in respect of such liability, being discharged by reason of the capitalization of the fixed annuities.
Yeah,
Is it the
that's
case-
getting into some kind of legal nuances that either escape me or I'm not sure what you're asking.
Sure, so if you don't understand the legal nuances of these arbitration awards, how can you make the comment about what would be disappointing to the province?
Well, two facts. One is that Moat was pretty clear in his legal opinion. Secondly, Ontario was adamant right into the 1890s that it was not liable to pay in treaty annuities.
Even though it was bound by the arbitration award of 1870.
Well, Moat explicitly used the 1870 decision to suggest otherwise. His interpretation was that, look, our legal counsel, Ontario's legal counsel, went before the Board of Arbitration in 1870. We made the argument forcefully, and it's always been our position that we do not, that we are not liable for this amount. I mean, whether they actually are or were under one arbitration award or another is really a legal question. I can't give you an answer, but what I can tell you is what the Crown actors were doing, what they were arguing, what their positions were. And I leave the actual legal interpretations to you folks who have a lot more experience in that regard.
Okay. All right, then let's look at slide 133. All right, so we're talking about now I'm looking at slide 132 as the intro, where you're talking about the 1895 decision of the Supreme Court of Canada, Chief Justice Strong in particular. And that Chief Justice Strong's interpretation being that, and here, oh, I see my friend has brought it up. It's in the italicized portion, the third line down. There is nothing, the end of that line, there is nothing showing that either the original annuities of £600 and £500 per annum, or $1.60 per head of the respective bands of Indians, were to be paid out of the proceeds of the lands or out of any particular fund. So this interpretation that there's nothing showing that the annuities were to be paid out of the proceeds of the lands. Is that what you're referring to at slide 133, your first bullet point, when you say this interpretation is consistent with the actions of Crown actors who for 44 years had never paid either the pre-augmented or augmented annuities from the proceeds of the lands?
Well, it's the paragraph in its entirety. Because Chief Justice Strong goes on to say that, this does not mean that the increase was to be paid out of the proceeds of the lands, but has reference only to the event in which the increase was to become payable.
All right, so then back to slide 33. you say that this interpretation, which you've now helpfully expanded for us, is consistent with the actions of Crown actors who for 44 years had never paid either the pre-augmented or augmented annuities from the proceeds of the land. So that's the interpretation we're talking about, correct?
Yes,
And you told us that the Anishinaabe expected that the annuities would come from the proceeds of the land. Isn't that right?
yes, I concluded after looking at, all of their the evidence relating to their viewpoints that at the time of treaty and in the years thereafter, they had expected the annuities to be paid from the proceeds of the lands.
All right, so if the Dominion was paying the augmented annuities pending resolution of ultimate liability as between it, Ontario, and Quebec, and that's in fact what was happening, am I right? The Dominion was paying the annuities pending resolution of this issue?
The Dominion was paying the annuities irrespective of whether the issue was pending or not, because keep in mind that for long before the arbitration of the 1890s, there was no progress whatsoever. There was nothing pending, literally, right? So it was only reinvigorated in the 1890s. So I mean, the Dominion continued to pay, even though at the beginning of these payments, it was understood that the question of who should pay was pending and would very soon go to the courts, because Blake himself was involved in trying to set up a Supreme Court. And he and Mowat had anticipated that this would go to trial, to the courts for decision, within a year or two at most.
And it ended up taking 20 years.
Yes.
But it is the case that all of the parties, when the Dominion stepped up to the plate and said, we'll start paying the increases up to $4 in 1875, all of the parties understood, well, we still need to figure out who's ultimately responsible. We'll do that either by way of litigation. In fact, what ended up happening was arbitration 20 years later. Isn't that right?
Yeah, I didn't find in the record any indication that they were sort of actively, either side was actively involved in trying to get this resolved in the courts. I really don't know what happened. I kind of lost trail of any kind of correspondence that related to the continuation of the effort to have it resolved in the courts. And the next time we really hear about it again occurs decades later.
So it certainly took a long time, but the fact that it arose decades later means it was still yet to be determined. Isn't that right?
Yeah, I think Canada certainly understood it needed still to be determined.
All right. So if Canada is paying these augmented annuities with the intention that eventually they'll sort out with Ontario and Quebec who's supposed to be funding them, in this period of time before the arbitration, before they get to sort out this issue of who's ultimately responsible, how could the Dominion be paying out of the proceeds of the lands when it was Ontario who was collecting the proceeds of the lands?
Well, I mean, exactly. Canada could not pay them out of the proceeds of the lands because they had no access to the proceeds of the lands.
And that makes sense. The Dominion couldn't pay it out of the proceeds of the lands. That makes
Yes,
sense.
but Canada had a solemn obligation to pay the Anishinaabe their annuities. And they took on that mantle in 1875, and to the credit of both Canada and Ontario, it was decided that, the Anishinaabe should not be disadvantaged and were given the benefit of the doubt, and Canada continued to pay the $4.
So why is it relevant that Canada paid the $4 out of its CRF as opposed to from the proceeds of the land? How is that relevant?
Well, to the
Right.
Anishinaabe, I'm sorry, to the Anishinaabe,
Relevant to what is a legal question, or is it relevant to some of the fact?
Well,
Well, it's relevant to the fact that, to me, that this witness must have pointed out more than 1 dozen, perhaps 2 dozen times, the source of the funds. And I never knew myself why it was relevant to point it out so many times. So I'm happy for the question.
so you have told us a number of times the money was paid out of the Dominion's Consolidated Revenue Fund. It was never paid from the proceeds of the lands. And now you've agreed that, well, it couldn't have been paid by the Dominion from the proceeds of the lands because they didn't get the proceeds of the lands.
that's correct.
So is it at all relevant, the fact that you have told us that it was paid out of the CRF by the Dominion? Is that significant to your opinion?
I was asked to look into what the Crown actors actually did to pay these annuities. And I went and I sourced the origins of the funds and their ultimate destination from one end to the other. In the course of doing so, I found that the proceeds were consistently, or I should say, the annuities were consistently drawn from the CRF, which is consistent with the other treaties. Of course, from the Anishinaabe perspective, it didn't matter where the money was coming from, as indeed the Judicial Council of the.
Yeah, I think you're going a bit beyond the question. You know, when you start talking about the Anishinaabe, their interpretation, there is a very specific question. You've heard that it's a question I have as well. And you started talking about the scope of your retainer. Which I'm not sure that's responsive, but maybe you can ask the question.
I'm sorry, Justice Hennessy, I'm deliberately I'm trying
Okay.
hard not to interrupt the witness because I don't want to make things difficult for the reporter. So I've been trying to hold back. But I actually probably have another half hour of questions, and I wonder whether it might be an appropriate time to take a break. It's almost 11:30.
Oh, I see.
But
All right. And we'll
given
take
that I
that break.
probably do have another half hour, I don't think I can
Okay, let's take that break.
breeze through.
We're gonna take a break. I'm gonna stay here. Thank you. 15 minutes.
This court will recess for 15 minutes. Resuming at 11:40. Thank you.
Dr. Brown, Gernet, I'd like to move on to slide 139. And here you're talking about, in the course of the 1892 arbitration, the three governments worked out a settlement. And here you're telling us about their joint agreement. Is that right?
Yes,
And in the second to last bullet point, you say, Ontario and Quebec, as representing the former province of Canada, were to pay certain amounts of money in arrears up to the end of 1892, as well as $205,000 capitalization amount in extinguishment thereafter of any claim by Canada for further reimbursements relating to the Robinson treaties. By reimbursements, are you referring to payments by Ontario and Quebec conjointly to the Dominion to reimburse the Dominion for annuity increases the Dominion was paying and would pay. What I'm asking is that what you meant by further reimbursements?
Well, this is coming from the language of the order in councils, which I reproduce at pages 401 through 402. So this is what I'm trying to reflect is the language as you see in the order in councils.
Can you point specifically to a particular passage you're talking about? I'm not saying you have to, because I think we're agreed on this point.
Yes. Well, again, these slides, of course, are, as you can see from the bottom of slide 139, are based on a lengthy analysis that covers several pages in my report.
Maybe just to get back to the nub of my question. My question is, when you say further reimbursements, what you're referring to is the fact that Ontario and Quebec were conjointly liable to pay back to the Dominion whatever the Dominion had been paying or would be paying in increased annuities. That's what you mean by
Yes.
further reimbursement?
Yes, this was for any and all reimbursements that the provinces of Ontario and Quebec were liable for.
So let's look at slide 146. And here I'm interested in your second bullet point. Here we're into your summary in chapter 7. So here you're summarizing points you've made earlier in your exhibit 52 and in your testimony. And in the second bullet point, you say, in 1869, Canada paid for a capitalization of the annual commitments for the RHT and the RST in the collective amount of $88,000. This money did not come from the proceeds of the lands, but rather from Canada's CRF. And I put it to you that this bullet point is inaccurate in two ways, or it's at least incomplete. The first sentence says Canada paid for a capitalization of the annual commitments in the collective amount of $88,000. But in fact, the $88,000 was added to the debts of Ontario and Quebec, and they were held by the arbitrators of 1870 to be responsible for that capitalized amount, Ontario and Quebec. Isn't that right?
Yeah, I don't know how that accounting actually occurred. I mean,
I don't think the question's about accounting. The word was, and they were responsible for that.
yes. They were under the arbitrators' awards, they were responsible for it. but in 1869, there had not been any arbitration. So Canada paid for the capitalization from its own CRF. I don't know where, I don't know if there was an actual account that was separate from the more general account that had.
Sir, I just remind you, the question was responsible, not
Yes.
whether there was an account or how the accounting was done.
Perhaps we could put it this way, to use your language before, of reimbursement. So Canada paid the $88,000 capitalized amount, but then was reimbursed by Ontario and Quebec. Is that right?
I don't know that as a fact, but I can only assume so if it was a consequence of an arbitration decision.
And this is where we got into the award. This is later referred to in the third award of the 1892 arbitrators. And I think you told us then as well, you really didn't know what happened,
Yes,
what was referred to when the arbitrators said that Ontario and Quebec were not absolved by having paid that capitalization amount. You're not really aware of this, are you?
yeah, as I said, I don't know what the legal nuances were in that language.
All right. So the second part of that bullet point, this money did not come from the proceeds of the lands, but rather from Canada's CRF. And I suggest to you that this sentence is a bit misleading as well, because the money could not have come from the proceeds of the lands if Canada was paying it.
Well, it's not misleading at all. I mean, it's a fact that it didn't come from the proceeds of the lands, and it's a fact that it came from Canada's CRF. And I made it clear that, you know, under the DNA Act, Canada no longer had control over the proceeds of the lands.
When you say Canada no longer had control, do you mean that at some point Canada, the Dominion, did have control over the proceeds of the lands?
No, you're right to once again qualify it with the Dominion. The Dominion of Canada did not have control over the proceeds of the lands. The previous province of Canada had control over proceeds from the lands.
And that control over proceeds of the lands passed from the province of Canada to Ontario. Isn't that right?
And Quebec. Yes, if there were any proceeds from Quebec, which of course there weren't. So, but because it's a unified province of Canada, the liabilities were understood to be shared by the two
But I'm
upper
talking
and lower
about,
Canada.
right, but I'm talking about at Confederation. The proceeds of the land moved from the province of Canada,
Yes,
which included Upper and Lower Canada,
yes,
to Ontario alone. Isn't that right?
yes, because only Ontario had pre-Confederation treaties.
No, I'm talking about the proceeds of the lands. The lands went to Ontario at
Yes, that's correct.
Confederation. Did they not?
Yes,
And so Ontario had sole control over the proceeds of the lands after Confederation.
that's
Isn't that right?
correct. That's correct.
Thank you. Okay, I'd like to move to slide 155. Here, again, we're just in your conclusion section, so we're going over old ground. But I wanted to make it clear because you reiterate the point in your conclusion section. I just want to get back to this point. The last point on this page, you're summarizing that the Dominion had started to pay the increased annuities up to $4 as of 1875, and you're stating in your last bullet point, thus an interim measure turned into a permanent charge against the Canadian budget. And I think you had told us earlier, it wasn't in fact a permanent charge because the whole issue of who is ultimately responsible, which level of government, was still to be determined, and in fact wasn't determined until about 25 years later. Is that right?
Yes, it was not a permanent charge in that sense. It was a permanent charge in that it was an annual budget allocation that was set for decades, year after year.
So I think you told us before it was an interim permanent charge. Is that right?
Yes,
All right. And I've shortened my questions, so we're now on the last one, which is slide 159. And again, I just want to go back. This is something we've talked about earlier, and here you're making a conclusion on, again, the augmentations to $4 per person in 1875. And your last bullet point says, once the decision was made in 1875 to augment the annuities to what was understood by Crown officials to be their maximum, and then to keep paying this amount by means of an annual grant drawn from Canada's CRF, there was no need to keep track of future proceeds from the lands for treaty purposes. And here I think we've already established that although it was by means of an annual grant from Canada's CRF, that was subject to later arrangements, which came into place late in the 1890s. But this point about there was no need to keep track of future proceeds from the lands. In fact, Ontario, there was a need for Ontario to keep track because this issue of who was responsible hadn't yet been resolved. And that's why Ontario did end up going back to determine what the proceeds were all the way up to 1892 at least. Isn't that right?
well, I can only go by what the individuals, the individual Crown actors actually did. And they did not keep track of future proceeds except for the purpose of determining the amount, if any, of the arrears
But let's,
until the 1890s.
and then in the 1890s, it was important for Ontario to determine what years had net profits, because that was relevant to Ontario's own liability. Isn't that right?
Yes, but at that point, all the parties agreed that the liabilities were not the full $4 every year that the Dominion had been paying all along. There was some liability, but it was not in the amount that the Anishinaabe had been receiving for the entire half century or quarter century.
So is this where you're getting to? You'd said in one of your slides that we can pull it up, that it was paradoxical that Canada began augmenting annuities when, according to Ontario's numbers, the treaties were actually suffering losses. Is that correct?
Yes.
And is it not the case then that Ontario at the time of that 1890s arbitration and settlement negotiations with Ontario and Quebec, was it not the case that Ontario was taking issue with the fact that Canada had paid ever since 1875, and Ontario was saying, but you know, Canada, you've paid, Dominion, you've paid for years that you didn't even need to. We're not liable for years that a net profit wasn't realized. Here, let's show you. These are the only years where net profit was realized. Isn't that right?
That was part of the dispute, which they eventually settled through common agreement as to which years were and were not.
Because Ontario was taking the position that it was only going to be responsible for years in which its records showed that there were net profits.
Yes, I think Ontario's position that is, look, if we have any liabilities at all, let's then go back to the numbers and see what the maximum extent of those liabilities are. But until that point, it was Ontario's argument that they, you know, that they didn't have these liabilities, right?
Right. So when they believed it would just be the Dominion that would pay, they didn't bother or need to bother to determine proceeds. But once Ontario realized that it would bear liability, it wanted to go back and look and see were there actually net proceeds. Isn't that right?
That's right.
All right. And also Ontario at that point, in late in the 1890s, complained about the fact that in Ontario's view, the Dominion was being too liberal in its determination of who it would pay the annuities to.
That's correct.
And Ontario had these concerns about the Dominion having paid for years. There were no net profits, and the Dominion having paid more individuals than was strictly necessary. Ontario had these concerns because Ontario knew it would end up being conjointly liable with Quebec.
Yes.
Thank you. Those are all my questions.
Thank you.
Good morning, Dr. Von Gernet.
Good morning.
If it can please the court, I have prepared a cross-examination compendium, which I'm handing out to everybody right now, and which Dr. Von Gernet, you're going to get a copy, and for the most part, but not exclusively, it includes all exhibits that are already in the cause. There are a couple of new documents that we'll get to that the witness might be able to identify, but for now, it would make sense to have the Dr. Von Gernet cross-examination compendium marked as a lettered exhibit.
Q,
Okay.
exhibit Q, thank you.
And Dr. Von Gernet, I think for some of the questions I'm going to have for you, it would be useful to have your curriculum vitae updated, which is exhibit 51, I believe. Your slide decks 52 and 53, and your reports exhibit 49 and I believe exhibit 50. So there's a lot of paperwork there, but I'm going to try and first off, I'm going to stay away, Dr. Von Gernet, from questions as best as I can from questions about things that have already been decided by the trial judge in phase 1 and by the Court of Appeal in phase 2. And I'm going to try and deal with your evidence in the spirit in which I believe Ontario intends to put it forward to the court. But the first thing I wanted to start with is your curriculum vitae, if you've got that in front of you.
Yes.
Now, I'm correct in understanding that you retired from being a professor in 2014, is that correct?
Yeah, I do not teach anymore, with the exception of a course on the history of tobacco, which has also been put in abeyance since the COVID pandemic hit.
So since 2014, you were only teaching one course in tobacco?
Since 2014, yes.
And where were you teaching that?
I was at the University of Toronto. It was not a course that I taught myself. It was rather a course. It was a team taught course. I taught the portion relating to the history of indigenous tobacco use and the consequent global dispersion of the practice.
And that was a paid position or an unpaid position?
No, that was not a paid position.
Now, I understand that you did do some field work according to your CV, and the last field work I can see being done is in 1996. Is that right?
Yes,
And that field work that you did was in archaeology, is that right?
yes, that was excavating an Algonquin hunting camp from the 16th century, which was located in the Upper Ottawa Valley.
Okay. And I understand that from reading your CV, you have testified, I think, 36 times in court from 1993 to 2021. Does that sound about right?
Yes,
And each time you've testified, it's on behalf of the government?
I don't testify on behalf of anyone. I am retained by various parties to provide opinions to assist the court. And it's true that that all of the retainers listed in that section are governments in one sense or another.
Is it fair to say, sir, that since 2014, you have been, your source of income is primarily comprised of income received from governments writing reports on which you subsequently testified?
No, some of my income has been from writing reports such as this one, the two that I wrote here for governments. There are other sources of income, including ones through retainers with First Nations that have not resulted in reports that have gone to courts and trial. There's also a great deal of work that's not related to litigation. So it's a mixture of income.
Would it be fair to say that a significant portion of your income comes from the government of Canada each year?
No, sometimes it's from a provincial jurisdiction, as was the case here, obviously.
So-
And one also has to keep in mind that when you say writing a report for, I mean, as you know, I've written many reports that were joint opinions, joint expert opinions, in which the parties are retained by, or which my co-authors were retained by other parties. And so the reports that I've written, and there's quite a few of those, are ones in which just because I was retained by one party doesn't mean that the report itself was written for that party. It was written as a co-author for reports that were then used jointly for various purposes.
Dr. Von Gernet, let's use the panel participation in the Alderville case as an example.
Yes,
That's what you're talking about, one of those examples, right?
yes, but that's one example. Another being the one that you were involved in northern Saskatchewan was the Dene, where I co-authored a report where after interviewing the Dene elders and I believe your clients retained experts as well, and we wrote a joint report and presented it. So that's another example of joint.
But, sorry, you want to finish? Anything
That's
else?
just another example of joint.
But you were
reports.
retained by the government of Canada in the Alderville case. You were retained by the government of Canada in the Dene case.
Yes,
You were the Canada representative on those panels, correct?
well, I'm never, just because somebody retains me, I don't represent them. I know that as an advocate, that's the way you operate, but not, an expert witness does not represent the party that they are providing reports for. They are retained by that party, but they swear an oath to provide an objective, independent opinion. And my objective, independent opinions would be the same irrespective of which party has retained me.
Your last peer-reviewed publication was in 2006, is that correct?
I haven't looked at it, but if that's that's possible.
You can take your time and look through it.
Yes,
Thank you, sir. I understand, though, that you deliver conference papers to Department of Justice lawyers, and in your CV, you've done that in 1999 and 2017.
from time to time, I am asked to give keynote addresses or invited to present papers at conferences in various contexts.
I was asking you about the Department of Justice.
Yes, including the Department of Justice.
And that's unique to the Department of Justice, where only Department of Justice people show up?
In those two instances that you're referring to, I would think that's the case.
Thank you. I note also, sir, that you have done no field work with the Robinson Superior Treaty Bands. Is that correct?
Yeah, that's not a necessary precondition for,
I didn't ask if
Yeah.
it was a precondition, just asking if you did any.
that's correct.
You haven't written any peer review articles on the Robinson Superior Treaty Anishinaabe? That's correct?
That's correct.
You mentioned that you wrote a joint report for the Dene in which you interviewed members of the Dene people to help inform your report. Is that fair?
Yes, I visited the Dene. And together with my colleagues and co-authors wrote a joint opinion based on our interviews with the elders So the oral histories related by the Dene informed our joint conclusions in respect to the Cold Lake Weapons Reserve.
Did you say Cold Lake?
Yeah.
Yes, the Cold Lake Air Weapons
Air
Reserve.
Weapons Reserve, yes. Their ancestors had used that reserve before it was established in the 1950s, I believe. And so we interviewed some of the elders who were still hunting in that area. And as you know, we produced a joint opinion in that affair.
My only point is that speaking to elders about oral and understanding their oral history was helpful to your opinion.
Yes, because the temporal context of the dispute was very recent. I mean, the government only established a reserve there in the 1950s. So this was not just oral tradition, it was actual oral history. These were elders who had actually been hunting there at the time that the reserve was established.
Dr. Von Gernet, your report speaks to the use of the land that was within the air weapons range for some time well before the living memory of the people you spoke to. Isn't that true?
That's correct. I thought it appropriate to provide a longer historical context for the Dene use of the traditional lands.
Thank you, sir. Can you go to your slide deck? Exhibit 53, the perspective slide deck, and go to page 7. At slide 7. A moment. Oh, I typed it wrong. It's slide deck 4. I apologize.
Page 4?
Slide 4, page 4 of perspectives report.
Thank you.
Slide deck. My apologies for misdirecting. I can't read my own handwriting. You identify in the middle and the second bullet of page 4 something called standards of my profession. See that there? Highlighted on the computer screen in front of you.
Yes,
And you say you're compelled by the standards of your profession to entertain assumption number 1 as a viable alternative. You see what you've said there?
yes.
I'm going to suggest to you, sir, that there are no standards of your profession that require you to entertain a hypothetical or an assumption that of that nature. Would you agree?
No, I would not agree.
Would you agree with me that you, as an expert, engage in hypotheticals all the time?
I don't engage in hypotheticals all the time. I do from time to time use hypotheticals or postulate hypotheticals in order to see what the consequences of doing so is on any conclusions reached. Sometimes it's necessary to have hypotheticals. For example, this past week, I provided a hypothetical involving what might happen if you applied assumption number 2. I was forced to use a hypothetical because there literally are no occasions in the record where we can explore what a shareable excess might look like. And so I used round figures and, that's a hypothetical.
Dr.
it's-
Von Gernet, I have searched in vain on the internet, looked at codes of conduct, and I can find no standard of your profession that requires you to have proceeded to entertain assumption number 1, which has been rejected by the Court of Appeal as a viable alternative. Can you tell me where there is a standard of your profession that required you to look at facts rejected by the Court of Appeal in your analysis?
During the normal course of my ethnohistorical research, I do not look to Court of Appeal decisions to guide the assumptions I should take. So the standards of my profession that I'm alluding to are not the specific one that you just entertained. Rather, the standards of my profession require me to ensure that when assumptions are adopted, they are historically viable. And in my view, assumption number 1 is very historically viable, as I think I demonstrated through a quarter of a century of Crown actions and their reasons for those actions. That's not a hypothetical, but that's an actual historically viable belief that Crown actors had for a very long time. So it's an assumption that's drawn from history. It's not one that's drawn from anything else, and that's all I can really say about it. And if I'm to draw assumptions, I cannot, as an ethnohistorian, we don't draw assumptions from 21st century legal decision making. That's not what we do. There's no context in my profession where I know that happens on any regularity.
Dr. Von Gernet, you were asked by the person that retained you, or the people that retained you, the government of Ontario. You were asked to prepare a report that assumed that the Court of Appeal decision was correct, weren't you?
No, that's not what I was asked at all. What I was asked is to read the Court of Appeal decision. I was also asked to, as I noted in slide 1, or number 2, to address the expert reports with which the plaintiffs had tendered in relation to Anishinaabe understandings and expectations relating to sharing.
All right, so let's be clear, sir, that the Ontario government never gave you any instructions to assume that the Court of Appeal decision was correct. Is that true? That's what you're telling us?
Yeah, I would not take on any project in which I was compelled by a client to assume that an historical fact has been settled.
Now we're getting to the nub of it. They told you to assume it, but you said you wouldn't do the work if you were asked to assume that.
No, that's not the way it worked at all. I was never asked to assume this as an historical fact.
Have you ever done work, sir, on behalf of a client? Whoever you owe your duty to, but whoever retains you based on hypothetical such as assume that the Court of Appeal was correct? Have you ever done something like that?
No,
You've never been asked to assume a set of facts in your work?
from time to time, I have been guided by I've been guided from time to time in what my focus should be, but I've never been asked to assume that a particular historical fact has been settled. And if I was so asked, I would resist on the grounds that if I am to provide an objective and independent opinion on anything, I have to be able to question any and all assumptions and be able to render a professional opinion based on what I regard as historically viable assumptions. And in this instance, assumption number one is an historically viable assumption. Now, it may
Wanna
not
continue
be,
on?
it may not be in accord with the legal assumptions or with legal decisions or with rulings of courts, but that's, as I said at the beginning of my testimony, that is not unusual. That happens all the time. There are many occasions where historians' understandings of the past differ from legal understandings.
I don't want to cut you off, sir, but I do want you to listen carefully to the question, and you can answer the question as however you want to answer it, but you know, I want to discourage you if I'm not being unfair from providing us with a response that is not really responsive. You know, if you need to embellish, fine. But if you could sort of try and focus on the question I'm asking, I would appreciate it. You testified last week that their just demand should be met without further delay report, which is subtitled A History of Government Efforts to Pay Annuities specified in the Robinson Treaties of 1850, that was a project during the pandemic. Is that right?
Yes,
And as I recollect the pandemic, it started sometime in 2019. Is that correct?
yeah, I started this later than that.
So when did you start it?
Well, it had fits and starts. I was not asked to write this specific report until long after I'd been retained by Ontario. I've been retained by Ontario under a different council than you see in front of you here.
That's okay.
To deal with entirely different matters. Most importantly, at the time, I dealt with the Robinson-Huron Treaty boundaries and the mapping of the treaties. So much of my early work on this file dealt with those issues, dealt exclusively with that. And so over the course of time, I was also asked to begin looking into the whole history. But that project, I initiated it probably by 2020.
when you say you initiated it, you weren't asked any questions, you just came up with the idea yourself?
No, I was asked if I could start a, compiling all of the documentation relating to Crown conduct in relation to the aftermath of the Robinson-Huron and Robinson-Superior Treaty. And so I started that process with the view of, at some point, putting together a comprehensive history. And that project, I had to set aside from time to time because there were other things that were happening, including other work that I was doing for other clients, but also because this whole issue of the boundaries continued to be problematic, and I was spending a lot of time on that project. So,
Okay,
I there's no point in time where I devoted 100% of my efforts to this until the latter part of the pandemic.
okay, well, I'm not sure when the latter part of the pandemic ends, do
That-
you?
That would be in the last year and a half to 2 years.
So approximately 2 years ago from today, or 2 years ago from the date your report was provided?
I'd have to look at my records exactly when the date was when I resumed more intensive work on this, but it was definitely in the last year and a half until the point when my report was actually released. I can't remember what the date is. Yeah, September 22nd. So,
Yeah.
so I worked on this definitely since 2020.
Since 2020.
Yes.
All right, and presumably you received some instructions on what to do, did you not?
By a previous council, as I said, there was a change in council in Ontario. The council that is in this courtroom today did not come into I had no contact with them really until later. So
My question was, you received instructions,
I
right?
received verbal instructions to put together a comprehensive documentation of the conduct, and B, start writing a history of that conduct. Anything related to the payment of the annuities under the Robinson treaties.
You received a letter or email from that council who is no longer here, correct?
I received a phone call. I know who he was. I don't know if I need to.
And who was
Name.
it? You can tell us.
It was a lawyer, Ontario lawyer by the name of Tortel.
Tortel.
Yes.
And are you going to tell me that Mr. Tortel never sent you an email or a letter telling you what to do? Is that your evidence?
I remember whether there are emails or not, I remember talking about it over the phone, definitely. Whether there were any follow-up emails, there certainly was no letter or mandate that I recall. There was no actual letter, as you see, which came later, but the letter which is reflected at page
I'm
slide
talking about
2.
Mr. Tortello. Let's
Yeah.
stick with him.
Yes, so no, he did not provide a letter, which is why the letter of instruction that is included in my with my report at the end as an appendix to my report.
All right, so
was
your
much later.
evidence, sir, is this correct? And you can tell me if this is your evidence, that the only written correspondence giving you any instructions to do the 2 years of work that you did was the letter of instructions dated June 2nd, 2022? Is that your evidence, sir?
No, my instructions at the beginning of my retainer with Ontario alluded to a number of projects, the most important one at the time being the boundaries issue. There was discussion along the way of also doing a history of the government efforts to pay annuities, but I do not recall any written letter with giving me specific instructions on what I should be doing or looking at, the way you see in the letter that is appended to my report.
Dr. Von Gernet, before you do any work for the government, you have to sign some sort of government retainer to get paid?
Yes,
Does that government retainer set out the work you're going to do?
not in this level of specificity as I recall. I'd have to look to see what it actually says, but I don't recall it being this specific. I mean, there's no, this whole project kind of evolved over time, and eventually I prepared this report. Everyone knew I was working on this.
I didn't know. I mean,
No,
who's
no.
everyone?
No, I appreciate that. But certainly, in terms of exchanges between myself and the province of Ontario, there was a constant going back and forth on various subjects related to this Robinson file. And sometimes this whole history thing was on the back burner for me for literally 4 or 5 months. It's not something that I knew that it was always there as something that I needed to complete, but I was under retainer, knowing that I would be engaged in a number of tasks, several of which have now not come to fruition because the RHT is no longer here. So a lot of my work involved that.
Thank you, sir. Prior to June 2nd, 2022, you received written communication either by email or by letter from people from the government, from perhaps Department of Justice, Attorney General lawyers, or perhaps someone from within government, giving you instructions on what to prepare that became their just demand. Isn't that true?
I do not recall any written instructions that specifically said, write this. What I did receive were a lot of emails relating to my requests for information from the archives. I received assistance to obtain materials from Ottawa. That was mainly the back and forth that I recall.
I'm
It
looking
was-
for,
I
I'm
was
looking for
always on-
instructions, sir. That's
Yeah,
all.
I can't recall an actual letter of instruction. I'm perfectly honest. I do not recall a letter of instruction.
Well, I expect you to be perfectly honest with me, so that's good.
Yes. I'm being perfectly honest with you. The only letter of instruction that I recall is the one that is appended to my report as an appendix, and that letter of instruction, I read it, and it was in accord with my general understanding of what I had been asked to do right from the beginning. There was nothing in it that was inconsistent with that. So to me, it was a written memorialization of an instruction that I had received from another council. Previous council.
Sir, might it be fair for me to say that prior to your June 2nd instruction letter, you had numerous telephone conversations with council from Ontario in which you discussed what that letter would say? Is that true?
Where are we going with this? I mean,
I'm trying to get,
it's relevant. I don't see that it's relevant. You have to find a question unless my friend is gonna be more pointed in why we're going down this path. We
This-
have an
this
instruction that is very clear.
The scope of cross-examination is pretty wide.
It has. But what is the point of this?
I'm entitled.
I'm just wait.
I don't see any relevance. I'm objecting to it because it isn't relevant.
Okay.
It is relevant. I'd like to know how it's relevant. If we need to make some submissions about that as matters of law, then we'll do that.
My
Mr.
position, I apologize. My position is I'm entitled to know if there are additional written instructions or how the written instructions came into existence. And that's not an unfair question, because if there is evidence and that the instructions existed in writing, or that the instructions were the product of a conversation he had, it wouldn't surprise me, but it's not an unfair question to find out what the instructions were and how they came into existence.
It is my view that this line of questioning is completely relevant. The instructions are have been a matter of inquiry in chief and in cross for every single witness. And I am not finding it easy to understand how this witness proceeded with these enormous reports on the basis of a single letter from Mr. Tortel that was not primarily about history, but was about boundaries. And the only letter of instruction is 3 months before voluminous, heavily researched report. So I find it troublesome. And I think this matter is completely relevant. Go ahead.
I'm just trying to understand, Dr. Von Gernet, how it is that you did your work for 2 years without instructions.
I had instructions, but the instructions you keep asking about written instructions, and I do not recall any written instructions. What I do recall are a lot of conversations about compiling a history of the government efforts to pay annuities. This may have been alluded to in the original retainer with Ontario. I know.
Do you have that
I
original retainer with you? Can we look at it?
I don't have it with me, no, but I mean, it's quite a few years ago. But I do know as a fact that I didn't do anything except some preliminary work on this in terms of compiling documents until I got waylaid by entirely different projects relating to the Robinson treaties. Both of I mean, the other projects basically consumed me. Most of it had to do with the boundaries issue. And so I worked on that for a considerable period of time. And then the 2 projects I started working on alternatively. One was put on the back burner, while the other one I
I think
worked
you told
on.
us this already.
Yeah, so
Dr. Von
that's
Gernet.
what happened. And then the perspectives one, that only came in later. But I was under retainer with Ontario. And my principal contact person was Mr. Tortel. And one other counsel whose name I don't remember, but I was also in communication with. And we had phone conversations in which they asked me, you know, what would it take to write this? And I said, you know, it's very complicated. The record is voluminous. And they told me to go ahead and provided me with assistance to the extent of answering my inquiries.
They provided you with oral instructions in addition to whatever you had in writing from the retainer, which you don't have with you.
Yes,
Thank you. Did you write down or record those oral instructions anywhere?
no, there's no need for that. I mean, a history of government efforts to pay annuities. I mean, that's something, you know.
We're talking about the instructions,
I
sir,
don't
not-
require reminding myself what I need to do. The scope was wide. Only confined by the fact that it was Robinson treaties and nothing else. And
I'm just asking if you wrote down the
No.
instructions you received.
no, not as far as I can recall, that there wouldn't have been any need to.
Well,
They-
can you
they-
turn to?
They left
Form
it to
50?
me, basically. I mean,
Can you turn
we
to
want a history and I gave them a history.
I'm not gonna do anything except take you to Form 53 at this point. Form 53. That's your acknowledgement of expert's duty.
Yes,
You take that pretty seriously,
absolutely.
and the way that you work is that after you complete your report, you sign your acknowledgement of expert's duty and send off your report. Is that right?
Yes,
So you completed your report on or about August 30th, 2022, and you sent it off to the government lawyers to look at.
yes, I sent them an ultimate report and they looked at it. And then I prepared my final report.
So you sent them a report that was not dated September 22, but it was a previous report. Is that right?
My practice, which I practiced in this case, is I always send them a draft to provide opportunities for correcting typos or making, grammatical or stylistic recommendations. And I'm the final arbiter as to whether I accept those suggestions or not.
That's fine. Just to be clear that there was an earlier report that
Yes,
is not before the court. That's true, right?
yes.
And you can't tell me now all the changes that were made to that report after your conversation with the Crown lawyers, can you?
No, all I can say is that, I do not accept any kind of changes to my content. You take it or leave it, is generally my approach. I do not tolerate extensive editorial interjections in my work. I am fiercely independent in that respect, so.
I want to talk a little bit about some of your methodological procedures, if I might. First of all, I think you told us, but we should be clear about this. You were not asked to assume in your reports that there was no cap on the collective annuity, but only a soft cap on the portion of the annuity that can be dispersed to individuals in any 1 year. You weren't asked to assume that in your report, were you?
I was not asked to assume anything.
You were not asked to assume that the conclusions made by the majority of the Court of Appeal were true, were you?
No,
Were you asked to assume that the findings of fact made by the trial judge were true?
no,
Would you at least agree with me that your report would look very different if you had approached your task assuming that the majority of the Court of Appeal decision was correct?
which report?
Both your perspective report and the just demand report.
The answer is that the just demand report would not have been possible to begin with if I had been told in advance to adopt as a fundamental assumption an a priori view that only one interpretation of the augmentation clause holds.
Not just one interpretation, sir, the interpretation that the Court of Appeal found.
Yes,
Isn't that important to you at all?
I would not have been able to write the just demand report because the Crown actors, if I am trying as an ethno-historian to explain a half century of Crown conduct, I need to know what their assumptions are, not what a modern court's assumption is.
All right. What archival research did you do for your two reports that are before the court here today? Did you do it yourself?
So normally, okay, so there's two stages to this. First of all, there was already an extant archival record that had been produced by the parties for stage one. That was a voluminous archival record. That was my starting point. Once you read, let's say one letter, and you see that the letter that it's responding to is not in the record, then you got to track that down. So there were two methods that I used in order to engage in that process. One was to ask for assistance in tracking these things down, because during the pandemic, it was not possible to travel to these archives personally. But there were, the government of Ontario had retained experts who do nothing else in Ottawa but archival research. They don't provide any opinions, but they provide the actual documents. So if I requested a document, they provided it to me. So that's another strategy. The third strategy is to research anything that was not in the original stage one productions online. And there are quite a number of resources that archivists have put online now, including, for instance, some of those, the Receiver General's books and things like that, which were not in the original trial productions, but which I found through other means, digging around online. It's sometimes not an easy task because these things are not cataloged very well.
Dr. Von Gernet, were you provided by Ontario with any new historical documents in preparation for your report that you yourself did not ask for?
No, that's not how it works.
No, I was
request,
asking.
no.
So the answer is no.
Yeah, the answer is no, and I would, that's not how I do my research anyway. I'm the one that asks for things and I get them. If the government of Ontario can assist with that, I have no problem with that.
So you did not, sorry, is there something you wanted to add?
No.
All right. You did not ask the government of Ontario or the government of Ontario lawyers, do you have any new documents to share with me that might be relevant? You didn't ask them that question.
I asked the government of Ontario to provide me with all of the archival materials that have been collected by all parties in relation to the first stage of this trial, stage 1.
Yes.
Some of it I had already, obviously, because I was a participant. I also asked for any documents that might have accumulated and been shared by the parties since that time, if such a database existed. And I asked for.
Let me stop you there. Did it exist? Did they share anything with you?
They did share some material that had been requested through me asking for research to be done. So I had asked that certain research, for example, relating to all the maps of that have ever been produced of the RHT and RST territories.
Yeah, Dr. Von Gernet, I fear we're veering off course here. I was asking, excuse me, I was asking specifically about, you responded, excuse me, to advise that if there were new documents that Ontario had produced after phase 1.
Yes.
Or had, that they would share that with you. And my question was, were there new documents that they had found after phase 1 that they did share with you? Not that you asked for specifically, but
Okay.
that you had asked that.
Yeah, I understand.
Yeah.
Yeah, no, not that I did not ask for. There was no, I'm the one that asked for this material. But Ontario shared it with me, having acquired it from a firm in Ottawa that specializes in finding material in the archives. So it was my request, and Ontario provided me as the go-between for that information. The request was made by me. I said I wanted, everything related, like the one I remember in particular, is everything related to the mapping of the Robinson Treaty boundaries. And I received a USB.
Is it possible, sir, that we don't need to hear about the boundary issue?
Well, that's the one that's prompting.
All right, you could
my
just say
memory.
the only things you remember are with respect to boundaries.
Yes.
Okay, that might be the end of that question.
Thank you. I'm going to try and be more direct, more leading here at this point. You asked for the government of Ontario or the government of Ontario lawyers to provide you with whatever documents they had that they've collected from other sources or other experts that might be of assistance to you. You asked for them.
Yes.
They did not provide you with the reports of the inspectors of the free ports of Gaspé and Sault Ste. Marie from 1865, did they?
I don't remember that particular report.
Maybe
No,
take a look at tab 14 of the compendium.
Tab 14.
And maybe you'll recollect having received that already. This is just
Of
an
exhibit
excerpt,
Q.
Of exhibit Q. Now, the complete report was entered as an exhibit in the cause earlier, I guess, last month. We're at tab 14. And tab 14 is stage 3 trial exhibit 17. And I've just excerpted some of it. You've seen this document before.
Yeah, so this document,
I've only asked you if you've seen it before.
yes, no,
You've seen it before.
I have not seen the actual. I've not seen this document except through the evidence of Dr. Bohacker.
So that's the first time you laid eyes on it. You didn't get
Yes.
it from Ontario.
No, I did not get this document from Ontario.
Thank you. I think that would be a good time to break for lunch.
Thank you.
We are definitely not going to finish today. But we do have some time tomorrow. I do expect us to finish the way I'm going sometime tomorrow.
Very good. And after you are finished, what do I expect? Mr.
Yeah,
Bass
if
is up.
it assists the court, I do anticipate some cross-examination for this witness, likely in the range of 1 to 2 hours.
Thank you. We can go off the record. We're gonna break for lunch.
Yeah.